Chicago conspiracy theorist Alex Jones arrived at a Texas courthouse for his defamation trial for calling the Sandy Hook Elementary School attack a hoax with the words, "Save the first" scrawled on tape covering his mouth. Jones is expected to testify Tuesday in his own defense. Here's a look at how the case relates to the First Amendment. Are all defamation lawsuits First Amendment cases? They are. Defamation laws evolved through decades of U.S. Supreme Court rulings on what is innocent protected speech. Why is his trial different? Jones seemed to sabotage his own chance to fully argue that his speech was protected by not complying with orders to hand over critical evidence, such as emails, which the parents hoped would prove he knew all along that his statements were false. That led exasperated Judge Maya Guerra-Gamble to enter a rare default judgment, declaring the parents winners before the trial even began. It might suggest Jones knew certain evidence would doom his defense. It is reasonable to presume that Jones and his team did not think they had a viable defense. And Jones made similar arguments in a deposition. If questioning public events and free speech is banned because it might hurt somebody's feelings, we are not in America anymore, he said. The parents suing Jones say his lies about their child's death harmed their reputations and led to death threats from Jones' followers. Are the parents public figures? Their lawyers say they clearly rent in the category of politicians or celebrities who stepped voluntarily into the public arena. The High Court, however, has said those who temporarily enter public debates can become temporary public figures. Reynolds told jurors that his client has been punished enough, losing millions of dollars being booted off major social media platforms. He asked them to award the plaintiffs $1. Can First Amendment issues influence the trial's outcome? Indirectly, yes. Jones can't argue that he's not liable for damages on the grounds that his speech was protected. The judge already ruled he is liable. But as a way to limit damages, his lawyers can argue that his speech was protected. But it would have been tough to persuade jurors that he was merely riffing and opining. It was a verifiable fact the massacre occurred at Sandy Hook, said Solomon. That's not opinion. It is a fact. Even if the parents were deemed public figures, imposing the higher standard, I think Alex Jones would still lose, he said. But Covert said defamation is always a challenge to prove. I wouldn't discount the possibility Jones could have prevailed, he said. As for tolerating homosexuality, as a nation we have chosen to protect even hurtful speech. To ensure that we do not stifle public debate, the ruling said. Not about any one person's reputation, Goldberg said. He added, "It'd be shocked if Jones' case ever ended up in the Supreme Court." For more of the AP's coverage of school shootings, https://appnews.com/school shootings.